Fagan, co-director here at CSAC and professor of political science. And it really gives me great pleasure to have Elena Kempf with us today. Elena was a visiting professor at Stanford last year, and I didn't know that until the end of the school year. And I said, "Oh, we didn't get you to come give a talk on your book project at CSAC," and I felt very badly about it. And she kindly agreed to fly out from MIT. So this is a really great time. She is the Old Dominion Career Development Assistant Professor of History at MIT. We'll be talking off of her book project. I just wanted to note that in addition to teaching and writing at MIT, she's become involved with the American Academy of Arts and Sciences through a project on the past and the future of the laws of armed conflict. So please join me in welcoming Elena Kempf back to Stanford.
Is this on? Yes. Okay. I'm so delighted to be here today. Thank you so much, Scott, for having me. I'm just so grateful also to all of you for coming to this room today, for taking time out of your busy schedules. And most importantly, Kate and Elaine, thank you so much for doing everything to make this visit possible and so enjoyable as well. Okay, so I'm a historian, and I don't know how many historians are in this room today, but fair warning, this will be history today, for better or worse. So in my talk today, I will be focusing on the arguments surgeons and scientists made about specific weapons in three crucial moments of law of war crisis and lawmaking. And I will be putting them up on the slides later again, but just to foreshadow this, the 1890s, the 1920s, and the late 1960s, early 1970s. And while most of you would probably be familiar with the history of anti-nuclear activism by physicists after 1945, the account I want to give you today will focus on the prohibition of some types of bullets, chemical weapons, and biological weapons. And what I want to convince you of today is that the ideas that informed these prohibitions were historically specific, that they changed, and that this history of ideas can be traced through the writings of scientists and surgeons. The people, in other words, intimately familiar with both the construction and the consequences of modern military technology. When reading international weapons law, the legal basis for weapons prohibitions looks like a story of continuity. Typically, prohibitions are based on prohibitions of unnecessary suffering, which is a core norm in international laws of war, and also the principle of distinction. But as I will argue today, the broader cultural ideas that animated these prohibitions are more wide-ranging than unnecessary suffering and distinction, and they tell a story of contingent historical change, of how the limits of lawful means of destruction in war were conceived and constructed. Now, this argument is part of my broader book project on the history of weapons prohibitions from the 1860s, when the first prohibition of a particular weapon was codified in St. Petersburg, to the 1970s, when the project of weapons prohibitions in international law returned after an almost 50-year hiatus. The book project is sharply focused on the particular, and some might say peculiar, practice of prohibiting specific weapons or classes of weapons through positive treaty law. I offer the first history of this project as an idea and practice. And in this history, I focus on people both expected and unexpected in this context. There are, of course, and importantly, the statesmen, diplomats, and international lawyers, the latter of whom have been identified by one scholar on the subject as the, quote, true actors in this history, but also journalists, novelists, surgeons, and scientists. The titular humanitarian calculus, to me, has a twofold meaning. The first literal, the second metaphorical. Literally, scientists calculated the limits of humanity in war using battlefield reports, photographs, X-rays, and advanced maths, and also wider-ranging considerations. In other words, what drove scientists and surgeons' ideas of the limits of acceptable weaponry were not age-old conceptions of honor. They were also not primarily conceptions about pain. Rather, they arrived at their ideas about the limits of acceptable weaponry through calculations and reason. The second meaning of humanitarian calculus in my work, as I said, is metaphorical. And that refers to the calculus that diplomats engaged in as they navigated their age's scientific, but also legal and political preoccupations. This metaphorical aspect, which is about the translation of broader cultural ideas about the limits of admissible weaponry into diplomatic and lawmaking fora, is not the subject of my talk today, but I'm happy to address it in the Q&A. Okay. So as I said, I will structure this talk in 3 parts and a conclusion. The first part is about a set of arguments that emerged in the 1890s in Germany. These arguments deplored bullets that caused wounds that would lead to inevitable amputation or death. The surgeons who made such arguments put forward a temporal humanitarian calculus that mapped onto the abilities of surgeons to mend bodies. At the heart of this calculus was the imaginary of the optimally calibrated, even humane weapon, and in this case, humane bullets. The second part of the talk is about an idea that circulated in the 1920s in networks of scientists advising the League of Nations in Geneva. It was an anti-apocalyptic calculus that ascribed world-ending consequences to chemical and biological weapons, or gas and bacteriological warfare, to use the language of the time. There could be no perfectly calibrated chemical weapons, opponents of such instruments argued. But at the same time, also in the 1920s, there were still other scientists who held onto the earlier 1890s version of the calculus. They argued that an optimally calibrated chemical weapon could exist. And lastly, the third part of today's talk takes us to the United States in the late 1960s and the early 1970s. At the time, the Vietnam War and advances in the biological sciences posed the question of chemical and biological weapons anew. Here, the calibrating and the anti-apocalyptic humanitarian calculus were both at work, but it was newly joined and undergirded by a calculus of uncertainty, I argue. Since the effects of biological weapons were not just uncontrollable, like chemical weapons, but also unknowable, such techniques, some molecular biologists argued, should be prohibited. Now, this history of varied arguments scientists and surgeons made on certain weapons offers 2 contributions to scholarship on weapons prohibitions and the laws of war. The first one is that it shows that such arguments have a history and that there are not, or not primarily, unchanging, almost anthropological laws that lead to the condemnation and eventually prohibition of some weapons. And to insist on this is surprisingly contentious. If you turn to the historical literature on the laws of war, references that trace the practice of weapons prohibitions to ancient Hindu law and the Greeks and Romans abound. And the idea that the primary driver of weapons prohibitions is revulsion, that is an emotional reaction, or prompted by novelty, by fear of novel weapons or ideas of violated honor abound. Such views of the history then give rise to a normalization of the modern phenomenon of codified prohibitions. It was hardly surprising, a representative quote articulates this view, that from the early development of the international law of war in the mid-19th century, efforts to reach multilateral agreement to regulate the conduct of war would include attempts to prohibit or restrict the use of certain weapons. And I argue against this narrative of inevitability. And the second contribution is that unpacking arguments made by scientists and surgeons against certain weapons takes away the illusion that what led to the prohibition of certain weapons was primarily a concern with pain, as one might think when coming to 19th century legal texts with a 21st century sensibility, or even just hearing the term humanitarian, right? We think of pain. Instead, as I show, scientists and surgeons' brand of humanitarianism had to do with limiting the temporal duration of damage incurred in war, with avoiding uncontrolled spread, leading to damage to cities or even mankind, and containing uncertainty. These three concerns, I argue, were also humanitarian. They were not just a fig leaf for the legitimation of military violence, as critical scholars have suggested, but yet I would still insist that they were still not principally about pain. They were not about the subjectivity of the suffering soldier or non-combatant. Okay, part one. This is blank on purpose. Here's the history. In 1890, in the middle of the Second Industrial Revolution, tensions between the major military powers in Europe were rising. At the center of these rising tensions, yes, on purpose, yes, pictures will come back. Thank you for the heads up. So at the center of these rising military tensions, of course, was Imperial Germany's naval program. But firearms and bullet designs were also changing quickly, offering greater reach, accuracy, and power. It was a time of technological change, in other words. At the same time, it was also a time of enthusiasm about the codification of laws of war, of international laws of war. Following the first international codification, a prohibition of explosive bullets in 1868, attempts had been made to create encompassing international laws of war in Brussels in 1874 and in Oxford in 1880. At the end of the decade, the Hague Peace Conference would convene and issue the Hague Rules of Land Warfare, as well as 3 prohibitions on specific weapons: expanding bullets, the throwing of explosives from balloons, so an early form of bombing, and the use of gas projectiles. The prohibition on expanding bullets that I just mentioned had its origins, I suggest, in the work of Paul von Bruns, a military surgeon and professor at the University of Tübingen in the South German state of Württemberg. His work on bullets arose from a sense of crisis. As weapons technology changed at an ever-quickening pace, he insisted that it took continuous study to keep pace to be able to mend the wounds caused by these new weapons. Therefore, he turned to the then emerging study of terminal ballistics, and these studies reveal his ideas about limits to legitimate weaponry. First, in an article titled "The Bullet Effects of the New Small Caliber Rifles, a Contribution to the Assessment of Bullet Wounds in Future Wars," you have the German here, published in 1890, von Bruns argued for the humanitarian character of small caliber, fully jacketed bullets, which had been relatively recently introduced. Based on a series of bullet trials, von Bruns and his team found that these bullets left wounds they described as pure and smooth. And you see here an example of one such reportedly pure and smooth bullet wound and its effect on a human bone. Exit wounds matched the size of entrance wounds, and bones did not splinter much. These types of wounds, von Bruns noted, were humane not only because they were relatively small, but importantly, because they could be healed. As long as the new small caliber fully jacketed bullets were used in future wars, according to him, quote, mutilation and crippling could be prevented more frequently. In von Braun's opinion, this meant that, quote, the new small caliber rifle was not only the best, but also the most humane weapon to mitigate the horrors of war as much as possible. Medical ability to mitigate the damage caused by weapons here rendered those weapons humane. The idea of the humane bullet, which von Braun invented, was then subsequently adopted by surgeons across Europe between the 1890s and 1914. And this idea, as you might expect, has been criticized by historians for its normalization of violence. And indeed, of course, the concept of a humane bullet is oxymoronic, and one looks in vain for any acknowledgement of the pain experienced by soldiers hit by such bullets in von Braun's work. But at the same time, von Braun's embrace of small caliber, fully jacketed bullets was carried by a commitment not only to soldiers' survival, but to their physical wholeness. Today, we might say quality of life after the war. So far, so good. Expanding bullets, a new type of bullet that had long been used in big game hunting, and that was then introduced by the British Army in India in the late 1890s, threatened to reverse the gains offered by the fully jacketed bullets. On this topic, von Braun gave a paper at the 27th Congress of German Soldiers in Berlin in April 1898. And in this paper, he called for the prohibition under international law of expanding bullets. This paper was based on a series of experiments in which he set out to confirm that the bullet had sufficient stopping power so that it was militarily useful, but also to confirm whether its destruction might go beyond the threshold of military force necessary. And if it were to go beyond it, he argued, that would go against the, quote, laws of humanity and would necessitate a call for humanitarian action. As a result of his experiments, and you see here an X-ray image that was part of this study, and X-rays have become commonplace to us now, but the X-ray was invented in 1895. And so this was really cutting edge technology at the time that was then mobilized to understand the effect of similarly new weapons. Okay, so based on this work, von Braun found that the expanding bullet caused lacerated wounds and splintered bones. Such wounds, von Braun observed, could not be mended and would overwhelmingly necessitate amputation, and therefore they should be prohibited. In the same article, though, he renewed his endorsement of the humanitarian significance of the earlier bullets, for which he helpfully reminded his audience at the Congress he had advocated from the beginning. So von Braun then, as we see here, had an ambivalent view of the relationship between new weapon technologies and the humanization of war. On the one hand, he was a techno-optimist, framing the new small caliber bullets as ushering in a humane present in which the effects of war would be limited in time. But not all technologies serve to humanize war. Expanding bullets threaten to undo the progress of small caliber bullets. And here he turned to law as a vehicle to humanize war, not technology. And von Braun is the central character in the story, but he was not working in a vacuum. He was part of an active circle of colleagues working in surgery in Germany. And here you have Friedrich von Esmach, who was a surgeon at Kiel University. And he wrote an open letter on the heels of von Braun's article in which he endorsed his colleagues' argument. And in this letter, he conflated the limits of acceptable violence and the limits of the capabilities of surgeons, much as his colleague had done. So here he argues that it is obvious that conservative surgery, so not amputation, but trying to heal a wound, which has been so successful in cases of bullet wounds in the last 50 years, would be powerless against such wounds, referring to wounds caused by expanding bullets. The only remaining option would be amputation if the wounded soldier would not have bled to death before due to the size of the wound. And because of this threat posed to the skills of surgeons by these new bullets, Esmach argued the upcoming peace conference at The Hague should determine that only such small caliber lead bullets ought to be used, which are either entirely or at least at the tip covered by a mantle of hard metal, so only non-expanding bullets. So I find at least two things remarkable about this story. The first, as I said before, is that here we see a humanitarian calculus in which the limits of acceptable injury were set by surgeons' ability to mend human bodies. This was not a question of the pain inflicted by the wound and the soldier's torment in the moment of being shot. Rather, this was a temporal and professional idea. What mattered was to contain injuries to wartime itself and to avoid enduring disfigurement. And the second remarkable thing about this story to me is that people like von Bruns and Esmach, who were surgeons, were at the same time deeply steeped in a culture of international law. So much so that it occurred to them to call on international law to limit the fast technological change that they had a front row seat to observe. The Hague Peace Conference, which met in 1899, as I mentioned, did prohibit expanding bullets, or in the language of the treaty text, quote, bullets which expand or flatten easily in the human body, such as bullets with a hard envelope which does not entirely cover the core or is pierced with incisions. As you can see, the declaration does not make a claim to principle itself. It doesn't give a reason as to why these bullets should be prohibited, but instead it bases itself on the spirit of the St. Petersburg Declaration with its famous summary and explanation of the principle of unnecessary suffering, if you're familiar with that law. So here's this preamble that the prohibition refers to. Yes, thank you. You can come up if it makes it easier to read. This preamble amounts to an explanation and perhaps even a philosophical summary, depending on which historian you ask, of prevailing law of war philosophy in the middle of the 19th century. And it effectively states that only necessary suffering, only the infliction of necessary suffering is legitimate in war. So if you read the preamble here, you can see that it doesn't mention any requirements regarding the ability to heal wounds, to avoid amputation, or any mention that would identify the limits of acceptable suffering with the abilities of military surgeons. This specific cultural meaning was created by military surgeons. But at the same time, as you can see, there was a conceptual openness here in the St. Petersburg Declaration, in that it could be interpreted to align with a prohibition on weapons causing lasting damage, unnecessary damage, one might argue. Okay, part two. So let me move on now from the 1890s to the 1920s, to the interwar period. The second moment of crisis, critical scientific engagement with the problem of modern weaponry, and international lawmaking. Now, this truly was a moment of crisis. In the aftermath of the industrialized carnage of the First World War, the project of weapons prohibitions was both weakened and perceived as particularly urgent. As Isabel Hull has demonstrated, among others, the First World War was fought over international law. And of course, the military of Imperial Germany had broken international law, including famously or infamously, the Hague Prohibition on the use of gas projectiles. Now, in the dire moment after the First World War, when the promise of international laws of war and weapons prohibitions seemed to be all but exhausted, many gave up on the idea of limiting and ordering war through law. But others remarkably doubled down on law because of the disappointment of the war and because of the fast pace of technological change. And this included scientists who foresaw even faster technological change in the future. So in the 1920s, we have a collision or a negotiation between two different ways of thinking about the legitimacy of different weapons. There is still the optimizing calculus from the 1890s that is seeking to conceptualize the humane weapon, the humane bullet, the humane chemical substance. But at the same time, we see here the rise of an anti-apocalyptic calculus that anticipates the end of the world imagined here as the destruction of cities and inescapable situations caused to soldiers. And I will illustrate this renegotiation through reports submitted by chemists and biologists to the League of Nations Temporary Mixed Commission on Disarmament, which met in Geneva in 1923. So I want to pause here briefly and say something about the relationship between scientists and international lawmaking. In the 1890s, Van Bruns had been very much an interloper. And in fact, I found out about him because British intelligence had collected his article and it then appeared in the British National Archives in Kew. Here, very much there was an active incorporation of scientific knowledge in the international lawmaking process. And the League asked biologists and scientists to comment on, quote, the effect which would be produced on human life, animal life, vegetable life, and on the wealth and resources of all kinds of a country attacked at any point within its territory by chemical or biological agents. The aim of the subcommittee in posing this request was, among others, to show the public opinion of the world the effects which could be produced by the most powerful means of destruction placed at the service of modern warfare by modern science. And in response to this request, the committee received 9 expert reports from chemists and biologists from France, Germany, the US, Belgium, among others. Okay. I will begin here with an example of the old calculus of optimal suffering. This old calculus was on view here in the report by Joaquin Enrique Zanetti. And in this report, he mounted a full-throated defense of chemical weapons. Zanetti had been a member of the Chemical Warfare Service for the US during the First World War, and he was a professor of chemistry at Columbia University. In the report, he sounded much like Van Bruns, as you will see. This type of warfare, chemical warfare, he claimed, is not only the most practical and inexpensive, but also a more humane and, from the military point of view, far more effective type of warfare than any known to the present time. Warfare using non-lethal chemical weapons would, he argued, permit the return to their normal occupation of soldiers who have been eliminated from the battlefield anywhere from 2 weeks to 6 months. So again, here we have a type of argument that conceptualizes weapons as humane if their effect was limited in time. And here, this temporal limitation took on almost magical properties, because in this case, in the case of non-lethal chemical agents, there was no need for surgeons for human intervention to mend soldiers' bodies. They would, in Zanetti's imaginary, recover on their own. Now, Zanetti's calculus about the humanity, even of non-lethal chemical weapons, it turned out was based on a really faulty read of World War I casualties. Casualties caused directly by gas were, in fact, comparatively low, but a chemical weapons attack often prepared the way for a kinetic attack with conventional weapons. But the point I want to make here by reading his work is that the search for the optimally calibrated weapon continued on and was applied to chemical weapons in this case. It had survived the industrial carnage of the First World War. Zanetti then was the techno-optimist of the interwar period, and he was not the only one. 2 years later, British geneticist and physiologist J.B.S. Haldane echoed his colleague Zanetti in his famous defense of chemical warfare, in which he argued that tear gas was, quote, the most humane weapon ever invented because of the temporal limitation. But some of the other reports that were submitted to the Temporary Mixed Commission denounced the use of chemical and/or biological weapons, and those were based on a new anti-apocalyptic calculus. And this calculus brought together concerns about temporal boundedness, which are familiar by now, spatial boundedness, and also threats posed to the integrity of science. So here we have the report by Richard Pfeiffer, professor at Breslau University. And in this report, I mean, if Zanetti offered the most full-throated endorsement of chemical weapons, Pfeiffer wrote the most full-throated denouncement of biological weapons amongst those who responded to the League of Nations. Right off the bat, he made a resolute appeal to international law in his unasked for condemnation of this class of weapons. At the very beginning of the report, which you do not see here, he writes, "I must emphatically state that I consider it a crime against humanity and all human feeling to think even of attempting to use for the destruction of life and health the achievements of modern medical science, whose aim is the safeguarding of human life and the prevention of epidemics." And he also warned of the difficulty of controlling such epidemics. They could not be limited easily to the enemy forces, but would soon spread to whole populations, including the arch civilians, the arch non-combatants, women and children, who would fall then victims to the disease. And here you see a similar condemnation of biological weapons because of their impact on non-combatants, women and children in particular. Finally, I want to draw your attention to Angelo Angeli, who was an Italian chemist and also the chairman of the Committee into Protective Measures Against Gas. And he too warned against chemical weapons. And to Angeli, in my interpretation, chemical warfare was a catastrophe of scale. There was no escaping them, leaving soldiers defenseless, even in those places which had formerly been regarded as safest. The large spread of chemical weapons was facilitated by their tiny size, which would make protective equipment increasingly less effective. Together, these two catastrophes of scale, on the one hand, widespread, on the other hand, a tiny size, would mean that such agents would have no difficulty reaching the men who form their target, wherever they may be. So there's a sense of a right to defense, or a sense of a right to protect yourself against a weapon here. Okay. So this is the legal text, the Geneva Gas Protocol of 1925, that many of you might be familiar with, that prohibited bacteriological and gas warfare. And here there is a gesture to the reason why such weapons or classes of weapons have been prohibited here. And that reason, which you see here, is the condemnation by the general opinion of the civilized world. But as you just saw, even amongst the tiny sliver of the opinion of the world that was demanded or asked for, solicited by the League of Nations, the status of such weapons had been contested. So here then is another example for why the inclusion of sources beyond the law are necessary to understand the genesis of legal codes. Rather than an enlightened general opinion of the civilized world expressing itself in law, the prohibition was the product of diplomatic negotiation unfolding in the context of a wider negotiation about the limits of acceptable weapons. Okay. So I want to briefly talk about part 3, and then I will conclude. Part 3. So by the 1960s, the laws of war and weapons prohibitions in particular were yet again in a moment of crisis. As Milton Leitenberg, a trained biologist and chemist who then specialized in arms control, pointed out in a piece in the small and short-lived journal Citizen and Scientist in 1967, quote, "There were several attempts to establish rules for international conflicts in the late 19th century. You learned about some of them just now, but these are too vague to have more than a cursory application to present CBW problems, so chemical and biological warfare problems." And you could imagine that this awareness of fast technological change and past failures or inapplicability of law would have made Leitenberg turn to other solutions, right? But this was not the case. Rather, this awareness of a history of technology making old law inadequate only prompted Leitenberg to double down on a call for more law. The only alternatives to the use of chemical and biological weapons, he suggested, appear to be more universal, more binding international agreements against the production and use of chemical and biological weapons. So we see here a broadening from prohibitions on use to prohibitions also on production and later research. And Leitenberg was not the only chemist or biologist in the 60s and 70s who endorsed international law yet again, despite it all. Here we have an article by Julian Perry Robinson, who was a British, not an American, a British chemist who worked on the prohibition and control of biological and chemical weapons, and who was a co-convener of a Pugwash group on the topic. He offered yet another answer to the question of the continuing appeal of legal prohibition in this article from 1975 in the Bulletin of the Atomic Scientists. Prohibition of weapons under international law, he argued, would protect against the assimilation of chemical and biological weapons. And this mattered, he argued, despite the record of international law, despite the fact that the record of international law in restraining wartime behavior is not impressive. So to him, to Robinson, It was international law as a shaper of public opinion and culture, not as a direct restraint on states, that mattered. And if someone can help me interpret here the illustration later, I would be grateful. So just because this recommitment to law is so interesting to me in this moment of crisis, I want to offer a third quote by Bernard T. Feld, who was a physicist at MIT. And he offered perhaps the most on-point statement about the importance of law in a moment of fast and accelerating scientific insights. In a defense of the Geneva Protocol and in his demand that the United States ratify the 1925 instrument, Feld pointed out that this protocol was important because of its attempt to hold a line against the exploitation for destructive purposes of man's rapidly expanding knowledge of the chemistry and biology of his own living processes and of the various living systems that support us on this planet. Okay. So out of this perhaps unlikely recommitment to international legal prohibition arose a wide literature that I've started to work through with some wonderful undergraduate assistants this last semester. And many of them were written for publications like Scientists and Citizen and the Bulletin of the Atomic Scientists. Much of the concern of these scientists mapped onto the anti-apocalyptic calculus from the 1920s for obvious reasons, right? Similar weapon classes, at least, were considered. So here there were again fears about the effect on civilians and the difficulty of controlling the path of a substance. But the specifics of this calculus had become more intense in this literature. Not only was it difficult to control the reach and extent of biological agents, but their very effect, and then also downstream effects in human and non-human species was unforeseeable. And from this observation and from this admission of scientific humility, some of these scientists developed a new humanitarian calculus of uncertainty. This is the last primary source I want to share with you. Thank you for your patience. Because here in this article, again by Milton Leitenberg, again in Citizen and Scientist, again in 1967, this calculus of uncertainty can be seen. In this article, Leitenberg called for humility. Scientists, he noted, had not yet learned to control bacteria and viruses. Outside of the lab, these agents, quote, may propagate, spread, evolve, develop relationships with other living things in ways which cannot altogether be foreseen. Here he warned of an unknowable chain reaction of alterations in many related life forms. Now, this was not the same argument as the one against chemical weapons, right? That chemical weapons might uncontrollably spread to affect non-combatants or one's own military forces. In the case of chemical weapons, the targeting was difficult to control, but the effect was knowable. What Leitenberg warned of here were unknown downstream effects of a weapon. Let me conclude. So in the time period we covered today, between the 1890s and the 1970s, surgeons turned to international law to prohibit expanding bullets and therefore safeguard their ability to mend wounds. The boundary between acceptable and unacceptable weaponry here was the ability to reconstitute the human body. Chemists turned against chemical warfare to protest the subversion of their discipline and warn against the twin catastrophes of scale. Chemical weapons threaten to perpetrate everything and spread anywhere. Here, the boundary was constituted by ideas about a right to defense and the control or controllability of a weapon. Biologists, finally, oppose biological warfare to caution against uncertain and perhaps unknowable downstream effects in humans, other species, and perhaps even the environment. The boundary here was constituted by the limits of knowledge. Uncovering this history restores specificity to the reasons why people oppose specific weapons of modernity at given times. Codified law grounds such prohibitions, as you saw, in abstract legal principles like unnecessary suffering and the conscience of the civilized world. And these concepts, as other parts of my work explore, do serve a really important role in the creation and interpretation of this law. There's a reason why international law was so attractive to surgeons and scientists. But it would be a mistake to assume that these principles led to the prohibitions in the first place, or even that they represent the fullness of concerns about transgressive weaponry. For that, the fullness of the involved groups need to be considered. Thank you so much. I know this was a bit longer. I really appreciate your patience. Wonderful.
And hopefully, so I like very much what you're doing here about looking at, opening the hood, use the metaphor, or going underneath to see what are the motives and the interactions among actors producing these rules. But it seems to me that one big difference between earlier ones and the 67 to 75 case is that the great powers, or at least a set of great powers, have nuclear weapons in 1967-75 and want to promote a ban. Sometimes people will call chemical biological weapons war bans, atomic bomb. The other reverse way that would come in here is that these agreements are the rich man's constraint on the poor man's weapon, or the strong nuclear powers constraint. Am I right that that's a big player that you discussed in the 67-75 case? And if so, what role did it play? And is there something else like that in the earlier cases where I don't know enough about the technology, but they want a constraint on something because they've got something else that can substitute for it and don't want other people to get it? This is a more realist take on what you're saying. I'd love to hear your response.
Yes, thank you so much for that question. I left out a lot in this talk, right? Because so in the book, actually, I also do talk about geopolitics and realpolitik and so on. So let me just say very briefly, yes, great power politics played a tremendous role in the renunciation of the biological weapons program by Nixon in 1969. And then also for US support for the Biological Weapons Convention in 1972, right? And as you say, one of the fears or concerns that animated US support for a biological weapons ban was precisely, I will just say what you said, the idea that biological weapons were the poor country's nuclear bomb. In other words, that non-nuclear countries, by developing biological weapons capabilities, which was seen to be much simpler, much cheaper than nuclear capabilities, could inflict real pain, real damage on nuclear countries. And so in a way, it would have been a leveling weapon, right? So that is absolutely at play here. And in fact, Milton Leitenberg, Matthew Michelson, who I didn't mention here today, but who was obviously a famous geneticist at Harvard at the time, who also played a huge role in influencing Nixon to renounce biological weapons in the late 60s. They all also discuss biological weapons as the poor country's nuclear weapon in those same articles that I shared with you today, right? So I focus, and in the existing literature on the subject, in fact, there's a fantastic work on humanitarian disarmament by Teresa Dunworth, and she devotes one sentence to the Biological Weapons Convention, and she says, because only state interests were at play, this convention has no justification, no room in a book on humanitarian disarmament. And so, first of all, I agree with you completely. Second of all, I want to challenge this neat distinction between either a political prohibition or a humanitarian prohibition, and show how they worked in conjunction. And even in this moment when, yes, if there's ever an example for a geopolitically motivated prohibition, this is it. And yet geneticists, right, like Nieselsen, and biologists like Leitenberg, they had it wasn't just cynical, right? They had real concerns.
For Richard Nixon, it probably was, but
right. Right. So I think I'm interested in stepping outside of the halls of political and diplomatic power and examining broader, you can't call it, so what is the social, right? But certainly broader scientific ideas about the limits to what an acceptable weapon is, and that's particularly important to me because modern weaponry, right, it's the product of modern science and technology. So where else to look than that? Okay, more to say on that, but is there something else like that, a prohibition on a leveling weapon? I mean, I am not an expert on medieval history, but sometimes it is said that the prohibition of the crossbow by the Second Lateran Council in 1190, I don't know, was motivated by similar leveling concerns because the crossbow, right, could be shot from far away and could potentially injure someone who otherwise would have been far superior to a poor person because of their better armor. But I'm really, on thin ice here with medieval history. Otherwise, in the late 19th century, I want to say no, and I want to say no in part, and then I will stop because I know there's so many questions, but the codified prohibitions are often the least common denominator. Sometimes they're face-saving moves that come at the end of the failure of far more ambitious agendas for quantitative and qualitative disarmament. So this is really the first one of such a leveling prohibition, I would say.
Interesting. I have Anna and Lindsay as the first two.
Thank you so much.
Can you introduce yourself?
Yes, of course. I'm Anna Ferl. I'm a postdoc here at CSAC. My research focuses on military AI and regulation. So a lot of the things that you spoke about historically, I feel like still apply to some extent to, emerging technologies and their regulations. I found your talk really, really fascinating, and I have a lot of questions, but I'll try to limit myself. And maybe,
please do, because there is a long list.
Yes. Maybe a comment on the crossbow. So yes, I agree. It was trying to level the playing field, especially, the royalty versus the peasants. But it was only, the prohibition was only targeted towards Christians and not used against people, in the Middle East and specifically in the Crusades. So I think that's also a very interesting point. I was wondering why you chose these cases specifically and not others, especially because there is such a strong history of kind of like weird prohibitions that don't apply anymore today. But I think, that could be really interesting to analyze with your logic and the different calculuses that go into that. So for instance, the whole debate about prohibiting submarines, prohibiting air warfare, these kinds of things. Why did you not take those into account? Or maybe you didn't just, and then-
We should make that the question because we've got 6 other people.
Fair enough.
Thank you, Anna.
Okay, why these cases? So constraints of the talk. So in the book, the case studies are 1868 explosive bullets, then 1899, the 3 prohibitions, right? Throwing of explosives from balloons, gas, but especially exploding bullets. And then interwar period, this moment of crisis, right? Submarines and military aircraft, which fail, right? But there were deep discussions about them. Gas. And then I end the 1960s, 70s are in a sense the coda, because it's this moment when after the hiatus, this idea yet again comes back, right? And the question is why and how, and maybe it's just all great power politics. So
give it an alternative explanation, not adopting that one. So
yes, so that's, and then just briefly wanted to comment on only valid in wars against Christian. This is another part that I left out of this talk at my peril, at my deep regret, and it's all over the book. Boundaries, right? Boundaries of these prohibitions. All of the positive international law of the 19th century only applies, right, as is well known, to wars between signatory powers. Only European states or European-esque states can be signatory powers. And then what is more, in the cultural discussions about what sets a weapon apart in a negative way, sometimes they're then associated with quote unquote uncivilized peoples, right? So especially when it comes to the use of poison. So the global context, global power hierarchies and the civilizational discourses are all over this, not just in the 12th century. Yeah. Thank you so much.
Lindsay.
I'm Lindsay. I'm a postdoctoral fellow here. I work on nuclear weapon policy and nuclear targeting, and have a radiation physics background, so also some science. So I guess if I could just ask, I noticed you danced around something that probably is like a big source of tension in both the analytical angle and also maybe law, but like where is the distinction between life and death in all of this? Because to me, a lot of the issues are, it's easy to estimate death with science and when you hit a death threshold, but then how do you estimate the quality of life is clearly a much more philosophical, legal, and technically challenging issue. And I'm also just kind of interested in this because philosophically, I feel like that's the issue going forward. It's like we've come up with all these ways to kill people, but now how do we know when technology actually like critically impacts life? So I guess it's a little philosophical, but there are technical angles to that as well.
Yeah, thank you so much for that question. That's part of the appeal von Bruns to me. That's why I'm trying to rescue him a bit from, and criticism of his work is well taken, right? He does legitimize wartime violence, right? At the same time, he does have this commitment to fixing the body against amputation and so on. So there is sort of a quality of life component there in a very 19th century way, right? Maybe almost not recognizable. Whereas if you read Zanetti, for him it's binary, right? It's life or death. He doesn't. He sort of dismisses ideas that exposure to a chemical agent, mustard gas, would leave any long-term consequences. I'm happy to send you that passage if you're curious. I mean, it's great, and as you say, it's a question that has stayed with practitioners beyond the scope of my project. I have some interest in the concept of superfluous injury and unnecessary suffering, sort of beyond the temporal scope of the book. And Robin Coupland, who's surgeon as well, and who worked or still works for the ICRC, he put together something he called the SIRUS project in the late 90s, the project on superfluous injury and unnecessary suffering. And he tries to define the boundaries of legitimate suffering there on the basis of a data set collected by the ICRC in a series of wars in the global south. And so it's a deeply imperfect project. All this is to say that the question that animates you is also one that I think haunts practitioners. And it's really hard to get a right answer on it, I think. Yeah, I would love to keep talking about this.
Maddie,
This was really great. Thank you.
introduce yourself.
I'm Maddie. I am second year PhD student in political science, also looking at international laws of war. I know that your book project will look at the politics side, but I'd be interested now if you could making a tie between the doctor's advocacy work and how that influenced policymakers, either through public opinion or more directly on the policymakers themselves. In 1898, it seems like doctors were playing a significant role in directly shaping public opinion, but in the latter two cases, it seems like the audience was mostly other elites because they were written in like academic journals. How did that connect to law, and why would they make a legal appeal in a scientific journal?
Okay, easy part first. Why would they make a legal appeal in a scientific journal? It's because the late 19th century is the great moment of legal codification internationally and also domestically. So von Bruns, right, he asked here for the prohibition of expanding bullets. Also, a few years later, he mobilized for the prohibition of certain types of, what do you call it in English? Like a match, you know, yeah, because he had identified, I think, some toxic agents in, I don't know, but it's still super interesting to me because I'm broadly interested in my work about thinking about the lives of law and legal concepts capaciously and tracking them down in places where we might not expect them, right? We expect references to law in the Huistenbosch in The Hague, right, where the Hague Rules of Land Warfare were negotiated, right? Of course, they're all well versed. That's their trade. But it is interesting that surgeons and also scientists, right, have this international legal consciousness, if you will, and that they connect that with their professional investments. You mentioned public opinion. In the 19th century, there is public opinion that is very, public opinion, what is it, right? But press opinion is very interested in the making. Humanized war. So the pacifist point, there was also the militarist point, right? That sharp wars are brief, famously, and so actually prohibiting some weapons for reasons of humanity has unintended consequences, and so on and so forth. So public opinion in this moment didn't care. So it was really professional groups in this moment in the late 19th century, surgeons and policymakers. But your question, how were policymakers influenced by surgeons? I want to say the realist thing here and say that there was a moment at the Hague Peace Conference when the committee that was tasked with disarmament, subcommittee 2, I believe, had hit a roadblock because there just wasn't support for the idea of wide-ranging disarmament of that type. Something had to be achieved, right? They had met at the invitation of the Russian Tsar. And so one of the delegates, and I have to look up again who, brought up the idea of prohibiting expanding bullets. So they had become a bit of a cause célèbre. This article in 1890. So people knew about it. So we have to do something. So let's prohibit those bullets. Was a little bit the sense I got from reading the transcript. So
It'll be a real failure
it
if we
was
don't
also
have something coming out of this meeting.
something coming out of this meeting, and
That's
also
really-
something that will embarrass Britain, right? Because Britain at the time was the only country who actually had produced such weapons for use in infantry. Yeah.
I have Herb and Rachel and AB. Does anybody else? Yana. Okay, for first Herb and then Rachel and then I.
Oh, sorry, my body allergies. Other biological weapon, I guess.
It's true.
You still have to introduce yourself, even if you're coughing.
Glad I do emerging tech. The at a high level, what I take from your talk is that the stated reasons, at least as articulated in all of the treaty language, and so on, different language, different rationales for different kinds of weapons. Was that a surprise, or were you expecting that to have all a common uniform rationale for forbidding certain things? To me, it's not at all surprising. You have different weapons, different mechanisms for injury, and so on, different rationales. Why? What am I missing?
I've asked that question for myself a lot, right? So you're basically asking the techno-determinism question, right? Are people just adapting? I don't find that in my sources. So
You don't find that in
I
you?
don't find, so to some degree, of course, that's true, right? So arguments against submarines in the interwar period, right? Can you hear me?
Yeah.
Okay. They are about disruptions to global infrastructure, right? And you can't make those arguments about a bullet, obviously. But I think what I'm after is sort of something beyond that, something sort of more deeper, something structural. And it might become clearer if I talk again about the different arguments about arguments are in part, or they're responding to specific technology that's in part my point as well. Because if you look at the legal history, and I don't fault international lawyers for this, right? But there are two big logics that drive the prohibition of particular weapons, right? Weapons that cause unnecessary suffering. That's one legal concept, unnecessary suffering and superfluous injury. And then weapons with a lack of distinction, which today especially applies to effects on civilians, non-combatants. And so in part, uncovering the technological specificities of these arguments is exactly part of my project, because that doesn't come through in the legal text. Yeah, let's talk later.
Maybe.
So hi, I'm AB. I'm a second year PhD student here at Stanford in the political science department. As being part of political science, I guess I want to go back to the politics. So another question that I have, similar to some that have been asked, but I would just like you to give a bit more insight on the interaction that scientists had with other actors. Specifically, I'm wondering about the obstacles that these scientists face during their advocacy. I know, like during the nuclear winter research, there was like the government was really highlighting by the implications that might come from that research. So I'm wondering how the advocacy by
The journal I put up where I think that's sort of emblematic of the thing. Of science. And the bulletin, of course. Yeah. In the case of anti-nuclear activism, yeah, you're right. Yeah. Different origin point. Yeah. But I will answer your question about obstacles faced by scientists. And so if you, there was a conference in Washington, D.C. in 1921, 1922. It was the Washington Naval Conference. And its main concern was with naval disarmament, but chemical warfare and also aerial warfare were discussed there as well. And so on the one hand there, you had committees that asked for public opinion input, and then also input from scientists. And here we actually again saw sort of, and if you're familiar with the history of chemical warfare in the US, it's not surprising, scientists actually sort of defended chemical warfare here. And in the end, public opinion carried the day because there were just, a great sense of fear of a future aerial attack on urban centers, New York, London, Paris, using poison droplets, aerialized poison droplets. So there's, if anything, only ever a crooked line between expert knowledge and legal outcomes in this work, which might be also something that you saw in your work. Yeah.
Rachel, are you still on the list?
Oh, yes, thank you. In
you.
fact, I'm probably picking up a similar theme there. I'm Rachel George. I'm a lecturer here and work a bit on international law as well. And thank you so much for fascinating. I think picking up a bit on these threads, like Anna, my mind went initially to kind of the contemporary challenges in modern warfare, AI governance, tech governance. But my mind also went to urban warfare and some of what we're seeing, kind of the efforts to bring in civil engineers, urban planners into the discourse on these ideas of unnecessary suffering, distinction, etc. And I was curious, I think, picking up on this last question, if you had any lesson learning, forgive me, like the political scientist in me wants to bring it to the contemporary, which I know as a historian is probably not the goal, but the way to which scientific experts and expertise were productively included or excluded, if you had insights on how that expertise is strategically injected into these humanitarian practitioner spaces, and equally, I know you talked about consensus among scientists, but was there also sometimes lack of consensus? And was that always a global scientific consensus? Like how globalized were these communities of scientists? And if there are any implications you see for kind of the contemporary efforts to bridge science and humanitarian practice?
Thank you for that question. No, and well, historians are reluctant to draw lessons from history. I think just very briefly, actually, the interesting thing in my work is that there's no scientific consensus, right? You have disagreements about, and I didn't get into this, but you have disagreements about whether a humane bullet is a thing, right? Is this a useful category? There are disagreements about which bullets have which effect. So similarly, right, disagreements between chemists, both sides. So that's one. And then lessons one is, this won't be surprising, but access to power, right? So I immediately think of Matthew Michelson, and he ran into President Nixon at Boston Logan Airport, apparently, and they had already been introduced before. They chatted, and Nixon reportedly, this might be apocryphal, right? Nixon asked him, so what will we do about your biological weapons thing? So access to power. I think there are the obvious things, because there is this real sort of public opinion work from the mid-20th century onwards with publications that are aimed at a more general readership than scientific academic journals. But I think the one lesson that does arise more specifically from my work, and that is not a direct answer to your question, is to not be constrained by existing normative frameworks. And because the existing normative frameworks were all new at some point, right? They were developed by international lawyers, or they were developed by surgeons and scientists. And it's really heartening for me to hear, and really interesting for me to hear, that you're bringing in engineers into discussions about unnecessary suffering. And I think that is, to me, really promising. And
Hi, I'm Jonna von Stein, and I'm at the Australian National University, but I'm visiting here right now. So I've sort of changed my question as the conversation has progressed, and I'm a political scientist as well, so sorry. I think we always want to know, what is the take home? What is, what's the story? So here, my question is, you put up your 3 cases at the beginning, and by the way, this is really fast. I find this really fascinating, because you're not looking at the treaty per se, you're actually looking at all the things that led up to the treaty. The treaty is just the end point. So my question is, does what you've shown us today, or in this broader project, does it help us at all understand the cases that never see the light of day because they fail for some reason? And I can think of a lot of different reasons that they might fail, but one of them, it seems to me, by fail, I mean just either take forever or maybe never even be codified in the treaty. I'm just wondering to what extent failed advocacy has anything to do with it, which of course is a function of the problem. But I guess I am asking you to tell us the take home on that one. Do you think there's some light to be shed on that question? I know we're just not fair. We always
no, it's just I think, I told you an intellectual and cultural story today, not the realist story, in part because the realist story is also deeply true, and yet it doesn't tell us much about broader, if you will, societal preoccupations and fears and opposition to certain weapons of war. But when you think about why, right, submarines were not prohibited in the interwar period, it does have to do with geopolitics, right? They were just too important to France, right? France had a ocean-borne empire there. I mean, probably all of this, right? Their surface fleet was much, much smaller than the British one. And so their argument was they needed submarines for their national security. And it's not an interesting answer, but that's what I do see in my sources, that even in the end, it's perhaps not forceful arguments about the immorality or immorality of certain weapons are important in building the case against them, but they're not sufficient, and they don't mean that prohibition will necessarily occur. And the interesting thing that I find in this history is then what's the tension between those two.
Right. Thank you.
Yeah. Sorry, not uplifting.
No, it's not, that's reality.
Yeah.
I have a last question, if I could. It's something that's always been puzzling to me, but I haven't seen others in this literature discuss it, which is, when you think about biological weapons and efforts to ban them, I think that one set of arguments about humanitarian concerns would say that, well, there's a difference between a infectious disease and a non-infectious disease.
That's interesting.
And I would think that if it really is sort of humanitarian protecting civilians, you could imagine non-infectious diseases that are exploited on the battlefield and don't have other kinds of effects.
Mm-hmm. I
don't know how to think about this in terms of like who had power for alternatives or countervailing capabilities. I would think some of the technical issues get involved here, but I just don't know the internal history enough to know, was this a big issue that people were debating, and why not? Because it seems to me that that's what I'd want them to, that's what I would have expected them to be debating, but I've never seen any discussion of it.
I also haven't seen any discussion of that yet. I have plans this summer to go into the archives of Milton Leitenberg, and so on and so forth. So I might find out. I think this point is super interesting, right? Because this argument in favor of non-infectious disease in battlefields would map onto arguments in favor of tear gas, right? If we assume it's also a non-lethal disease, right? I have not.
Well, it could be
seen-
lethal but not contagious, or it could
Right.
be, yeah.
Yeah, so both of these would exist, or could exist. I have not seen this at all. The most closely, no, but this doesn't really, vaccines come to mind, right?
Yeah.
And vaccines are discussed in this literature. And the point that I have seen in the Bulletin and Citizen and Scientist is, of course, that vaccines are specific to a certain disease. And so there's the problem of the arms race and of secrecy in biological research, which, of course, there's a long dream in international fora or among disarmament activists to make all research in the security relevant natural sciences public. That's debated in Geneva in the 1920s, and as we know, it failed.
It's debated today. Today too.
That's interesting.
Well, we should just conclude by all thanking you for, I think, what was a great talk and a very interesting discussion. We had a mixture of political scientists and some physical scientists and some lawyers too in the room. So I think that's great, and that's what we want. So I hope you'll come back when the book's finished, but we're happy to have you here and try out some of the ideas with us. Thank you for coming.
Well, so much.